Okay, so I think we're going to go ahead and get started. Good afternoon, everyone. I'm excited to welcome you to our highly anticipated webinar, Insider Tips for Music and Media Success. And I would like to extend a warm welcome to each participant joining us today. My name is Lorena Guzman Diaz. I'm an associate at Weissman Law, and it's my pleasure to guide you through this vital discussion, which is dedicated to empowering you with the knowledge to safeguard your creative endeavors and maximize your impact in the music and media industry. Excited Oh, does anyone hear my echo?
Yeah. Mute if you're on LinkedIn, mute that. That might be my fault.
I'm
Let's
not
do
on
that.
LinkedIn.
We're
Okay.
good. That was me. Sorry, everybody.
Okay. Back to where I left off. So today's virtual seminar is part of our ongoing series of online panels and webinars, which are designed to equip artists and content creators with essential legal and business knowledge that they need to thrive. Today's seminar is going to cover a range of topics tailored to the ever-evolving landscape of music and media. We'll explore cutting-edge strategies for branding and marketing your music in the digital age. We'll dissect the legal nuances of content creation and distribution, and we will share insider tips for monetizing your work effectively. Additionally, we'll focus on the crucial importance of understanding copyright law, negotiating contracts, and ensuring compliance with industry regulations. In an era where the lines between different media platforms are increasingly blurred, our speakers will also discuss multi-platform presence and engagement. This seminar is indispensable for creators looking to expand their reach, to protect their work, and to establish a formidable presence in a competitive market. I have the pleasure of introducing our distinguished speakers for today's seminar. So first, we have Adam Weissman, founder of Weissman Law, who brings a wealth of experience in guiding creative professionals through the intricacies of branding, intellectual property, and content licensing. Adam will illuminate the art of music branding and the complexities of navigating the digital marketplace while protecting your creative legacy. Next, we have Gerard Anthony, the music lawyer extraordinaire of Anthony Law Group. I know that whenever we have complicated music matters, Gerard is the attorney we always turn to. His expertise in live event production law makes him an invaluable resource for those in the industry. Today, Gerard is going to delve into the vital legal aspects of behind-the-scenes live event production, and he will address the necessities for successful festival organization, performance contracts, and risk management. So just a little bit about today's breakdown. So today's session is structured into a 40-minute panel discussion where our experts are going to be giving you insights on the intricacies and strategies crucial for music and media success. After the discussion, we'll open up the floor for a 20-minute Q&A session where you'll have the chance to engage with our speakers directly. And as always, your participation is highly encouraged. Before we dive in, I do have to disclaim that the information presented in this webinar today is for informational purposes only and should not be considered legal advice. Please consult with a qualified legal professional for guidance on any specific legal matter. So with that said, let's begin our journey today. Adam, the floor is yours.
Yeah, I just want to thank my good friend Gerard for joining us today. You know, over at Weissman Law, we do a lot of work in the creator space, in the digital space, in the production world, and music comes across our desk quite a lot. It might not be that we're necessarily representing in artists in the music space, but if you're doing anything these days that's online or has a production component, you need to have a general understanding of music law. So what we wanted to do today was, first off, start with a whole bunch of branding and licensing and online considerations you need to think about with music. I'm going to be doing a lot of talking, but I hope Gerard's going to interject, especially if I say anything that doesn't sound 100% on point. Gerard is one of the best music lawyers I know. I've had the privilege of being friends with him for almost a decade now. But what's more exciting to me than just the general music stuff we're going to talk about today is we're going to go into his wealth of experience as a music festival lawyer, which goes beyond anything that most music lawyers I know have dealt with. So I'm very excited to start with this initial piece that's going to be a little more broadly applicable if you work in any creative space. I think a lot of the things we're going to be talking about in this first half can apply to you. And then after we're done that, we're going to do a deep dive into Gerard's experience as a music festival lawyer, and hopefully tease out some horror stories from him, because those are my favorite parts. But anyways, with that, I'm going to turn the floor back to Lorena, who's going to sort of guide us through this, and we'll just go from there.
Okay, great. So let's start off with our first topic, which is the art of music branding and content licensing. Adam, can you explain why it's crucial for an artist or a content creator to trademark their brand, especially in today's digital marketplace?
Yeah, I think if you are starting off as an artist, whether you're a performing artist in the music space, whether you're a content creator, whether you are acting, anything else really, you want to think about what can you do to protect your brand. And in the case where you're the performer and you're the artist creating everything as an individual, one of the first things you want to think about is how can I register a trademark over my name, whether it's your actual name, legal name that you're using, or a stage name. Um, Doing that will help prevent other folks from using that name in their own context and ripping you off. Because the idea is when you start building up, you have that foundation, you're getting more popular. Your name might not be that exciting to other people to start, but after 2, 3 years in the business, people are going to try to go after that. So one of the very easy things that we always recommend, again, regardless of what type of media you work in or what industry you're in, is to consider going to the USPTO, the United States Patent Trademark Office, and filing an application to register your name there.
Do you have any examples of where it was really important for an artist to protect their brand? Any
Well,
specific?
one of the what I think is one of the wildest situations that has basically run almost parallel to my entire career path. Obviously, I've had no involvement in it. Is Beyonce's daughter trying to register the name over Blue Ivy, which started about 12 years ago, if I'm not mistaken. And there was an issue where there was some little store that was acting as the sole prevention from her being able to get the registered trademark over her daughter's name. And finally, they went through a bunch of iterations of that. January of this year, I believe, actually finally got the registered mark over that name, which means now that they can do things with it, they can sue over it. It's very difficult to start a lawsuit and protect a trademark if you don't have that registration. There are state remedies that you can go through and common law remedies, but if you don't have that federal registration, most of the options are not available to you. So now that's going to basically be the foundation they need to start protecting that name. They couldn't do that before, which 12 years of fighting for that is a very, very long time to miss out on.
Yeah, thank you for that. So turning now to more like negotiating licensing agreements. So from your experience,
Actually,
oh yeah,
I got two more. I got two examples.
please.
Please.
One that just came up, which I thought was pretty interesting. So, Kanye, crazy person, sent a text message or posted a text message between him and his ex-wife, Kim Kardashian, because recently Kanye released a song where he was using his daughter Northwest, I believe is that her name? Daughter's name
Yeah.
Northwest vocals on the song. And Kim, his ex-wife, let him know that she had owned the trademark and had trademarked all of their children's names. And Kanye in the text message was basically saying like he had no knowledge of that. I don't know if that's true or not, but he was saying he had no knowledge of that. And Kim was trying to use that to prevent the release of the song or get the song taken down. So that was one that I thought was pretty interesting because I never, it was actually brought up a number of issues in terms of like, okay, the name is actually trademarked, but does that implicate, because it's not just the name, but does that also implicate like name, image, likeness on the song as well too? So that was pretty interesting. I'm not sure where they landed on that. And then the other popular example that I don't know a lot of people know is that the late rapper the late rapper Notorious B.I.G. Originally, his original name was Biggie Smalls, but before I believe he released the first album, there was a rapper on the West Coast whose name was Biggie Smalls, spelled slightly different, but that is why he changed his name, changed his stage name, and released music under the name Notorious B.I.G. So I actually didn't know that for a long time, but and it's interesting because even later people use those names kind of interchangeably. Biggie Smalls, Notorious B.I.G. But he actually did not own the trademark to Biggie Smalls, and that's why legally he was releasing music under Notorious B.I.G. So again, that plays into your whole part about, the importance of trademarking.
And it's also a good distinction because obviously that wasn't his, legal name growing up, his
Right.
government name, right? That was his stage name. If you're using your actual legal name as your stage name or as your performing name, it's still a lot easier to get protection over it. You could have
Right.
other people out there using it, and as long as you can prove that it's you, you're often going to be okay getting that registered mark. But it just does go to speak to why you want to do that early on, because then if other people start using the name in the same way, if you have that registered mark in the first place, it's going to be easier to fight for. Of course, if you're coming up with a completely brand new name out of nowhere, yeah, you have to prove that you're using it yourself and that you're
Right.
the first one to do it. Well, those are excellent examples. The stuff with the battle between, you know, Yi and Kardashian over the kids is ridiculous. But that even just goes to show how, hey, if you're going to sample stuff, make sure you get clearance on that in the first place, because that would have avoided this entire battle, right? If there was
Right.
just like a release there, Kim couldn't make an argument about the name in
Right.
the first place.
Yeah. Well, thank you for that. So talking now about some negotiating licensing agreements. So Adam, from your experience with working with influencers and digital media, what are some of the effective legal strategies for negotiating licensing agreements that truly benefit artists?
Sure. And I'm going to give some points that are so broad that I think it applies to music artists. I think it applies to any sort of freelancer, anyone who's not even necessarily in the creative field, is that when you're starting out on your own and you're going to larger companies that need to hire you for stuff, whether it's a licensing agreement, whether it's a campaign agreement, whether even it's just like services agreement, know your worth and know how to push for that. And if you don't have a team on your side, you don't have a manager, you don't have a lawyer or someone to advocate for you, go out and talk to other folks in the industry and get an understanding of where you think you should stand from a financial perspective. And I think that's the biggest first piece of advice that I give everybody starting out, which is know what your value is, talk to other people, get a sense of it, because the worst thing that I see in our industries, and I'm sure Gerard probably sees the same thing, is artists starting out who just undervalue themselves. They get awful deals for the first 5 years of their career. And as a result, their starting point is way lower than they should be. And when they're somewhat successful 5 years out, they're still getting paid less than they should have because they agreed
Right.
to those not great rates. And then the other piece you need to think about, sort of jumping off of that, is we're talking about licensing. We're talking about your copyright, the stuff that you're creating. You need to understand how licensing works. You need to understand a little bit of licensing language and what licenses look like. And similarly, know that if you're getting paid X, the license should reflect a certain type of usage being granted to folks. The other biggest, worst thing we see all the time is if you are early artists who are agreeing to basically do full buyouts of their stuff early on, or grant unlimited license to people just because they're getting paid. And you have to know that $500 might be great for a 1 month license, but not great for a perpetual license. So understanding the distinction of you're getting paid not just to get engaged, but you're getting paid to give a specific type of license. Knowing how that license interacts with how much you're getting paid is really, really important. General thoughts from your end, Gerard?
Yeah, I was going to say generally, I think that most companies that are trying to acquire those rights, they're typically going to start with an ask that's going to be pretty broad. And then typically as a creator, your job is going to be to either like tailor or kind of pull back exactly what they're asking for. Obviously, the ownership is probably always going to be one of the most important parts of it. So understanding, okay, what are the terms of usage? When does this and again, the whole thing we're talking about licenses, so someone doesn't own it. So typically, when is that going to be coming back to me? Is it exclusive? Is it non-exclusive? Are you going to be able to exploit that content multiple times in other places? I think those are all things that you want to be able to protect. But to Adam's first point, I would say just the creators kind of undervaluing themselves or kind of getting spooked into thinking that like, I don't want to rock the boat too much because someone might not come back. Again, as long as you have great product, like people will come back to you. And I think that's kind of like the foundation to work from.
Yeah, yeah. I find, and this even goes for lawyers who are starting out their practices, like you're often your own worst enemy when it comes to your rates.
Sure.
and never negotiate against yourself. Start off strong, know what you're worth. And yeah, companies are going to come back and try to whittle you down a little bit. And that's okay too. That's their role. So always come out the gate strong, and you'll get, you should be pushing for what you deserve.
Thank you. How about, so let's talk a little bit about synchronization rights and kind of like how those differ from licensing rights, if you could give us a brief overview, but also how can artists leverage all of these rights for multimedia exposure while also avoiding infringement?
I'm going to let Gerard start with this one. I got lots to say from my perspective. I want to hear it from the musician's artist perspective first.
Right. Well, I would say the first part is you want to make sure you're clearing everything properly. Feel like so I have a lot of music producer clients as well too. So this comes up, nonstop in terms of clearing songs. So like let's say you sampled, let's just use an example. So you say you have artist A and producer A. We'll keep it simple. So there's only one producer. But like let's say this particular producer sampled a song and the as he was composing the beat, and then so now we have a new composition that also has the sample in it. But like let's say he never got the authorization from the original copyright owner to use the sample. And then like let's say a movie came and they wanted to use the song. So when the movie comes to clear the sync usage, they have to clear the master. So who owns the master? Typically, that's going to be the artist, and then or the label if he's in the deal. And then secondly, they got to clear all the writers and publishers. But because you use the sample, technically, the the writers and publishers from the song that was sampled would be included on the new composition as well too. So now you're in a little bit of a pickle because you need their permission to be able for the movie to be able to use this song. And if the song is actually already out and hasn't been cleared, now you're in a position where basically like they have a few options. They could pretty much take everything, including like the money that's been earned from the song. They could pretty much take pretty much almost all the publishing at this point as well too if the song hasn't been cleared. And there's, as you can imagine, tons of nightmare examples, as this applies. I think the one that always pops in my mind is feel like we're talking about on like a lot of late rappers today, but Juice World is another one. He had sampled I think a song from Sting, and the producer did, and he never cleared it. And when they did it after the fact, I believe Sting took maybe almost like all of the publishing on the song. But as an artist, you can go out and still perform and earn money. But as the producer, most of your money is going to be coming from the exploitation of the song, the royalties and stuff like that. So I would say number one is definitely making sure you have all the rights that you say that you do when you enter that agreement. A lot of people, a lot of clients, they kind of like they don't pay attention to that reps and warranties part of it, where it's like, hey, you pretty much promise that you have all the rights that you are entering to that you're giving away in this song. So if you don't, and then there's an issue down the line, you're typically, indemnification, which pretty much means like if I mess up and you have to pay, then I have to pay you back. Or if you mess up and I have to pay, then you have to pay me back. So in that situation, that producer would have to indemnify the person who's like either got sued or end up having to, pay damages on their behalf. But again, it all goes back to just making sure that, you have the rights that you're supposed to have in the beginning. And then another thing that I see a lot of times with that can happen with syncs as well too is we kind of touched on this in the last question, but sometimes you'll have artists or producers that'll just accept like a complete buyout on the publishing side instead of keeping that open, because you're really kind of betting against yourself because again publishing is definitely more a hits business, but you just never know what song might take off or something goes crazy on TikTok, or some song ends up becoming like the lead theme song of a show or a movie or a podcast, something like that. And now, you've kind of capped yourself on what you can earn because you took a complete buyout.
Adam, did you have any, you said originally that you had a lot of thoughts.
I mean, I've seen it from the other end where we're representing the producer on a film and engage a band or an artist, and they think they have 100% of the rights, and we kind of poke and prod a little bit. We're getting them, just like Gerard said, they're signing off on the reps and warranties and the indemnification. And I'm going back to my client, and I'm like, I feel like they're connected to a label. This doesn't seem right. And we reach out, and turns out the label has the publishing rights. And I've been in situations where, not with film, but with digital stuff, videos going out the next week, that maybe there's a brand involved. So it's a pretty high stakes thing. And what ends up happening is we have to get permission from the label. The label goes, wait a minute, we're not getting paid enough for this. And then it turns into a whole thing where the band might have said, yeah, we're totally okay with this usage. We're excited to have it featured in this video, but they're forgetting that 50% of the rights aren't theirs to give away. And what ends up happening is this happened 2 or 3 times when I was working with a magazine that was doing a lot of output on YouTube and working with brands, like doing sponsored videos. We had to shelve videos last minute and just totally redo the music because the bands didn't realize that their labels were just not on board for licensing out music in the way that they wanted to. So going back to Gerard's original point, like if you can't control that yourself and somebody else has that control, you can lose out on a lot of revenue there as well.
Well, speaking of licensing rights and opportunities, so what insights can you offer about cross-platform content licensing, especially, with the advent of VR and AR?
Yeah, I think the thing you need to be extra careful with these days is how nuanced and specific the license in your licenses are, because I'm still getting contracts that will, for like the media, where it's describing where something's going to live, it literally just says digital, and that doesn't mean anything. And I have these conversations a lot now where it's like, is digital streaming? I don't know. Is digital billboard that's in a mall? Maybe. Is digital a VR platform? I don't know. And the problem is, if that's not spelled out explicitly, it's going to likely end up falling in the favor of the licensee because they have the power to make those decisions, because they're the ones now who got the music or they got the other content, and they're like, okay, this is our hands now. We're going to put it out in those spaces that we weren't necessarily contemplating when the deal was being made. But the way this contract is worded so broadly, we think we have permission, and they're willing to fight over that. So I think that's the thing you really need to look out for these days more than ever. I remember back when I was started working with influencers like 8 years ago, just very simple concepts weren't written out in these licenses, and you had to really get into the nuances of it. Other side would be like, "What are you doing? It just says social and digital." I'm like, that's not meaningful enough. So that's the biggest thing looking out for now, just getting that specificity there.
Thank you so much. Gerard, do you have any thoughts on that?
Yeah, I was going to just say the context, like we talk about this all the time, is that even if you look at these contracts, you have to put it in the context of whatever business you in. Like the context of influencers is going to be different than the context of just like an artist releasing music, or the context of like a music festival. So these clauses and these phrases are not one size fits all.
Yeah. Yeah. Understanding your industry is key. And if it's an industry you're new to, asking other people about it is key, because there are terms in music agreements that are going to mean completely different things from a production agreement that I deal with.
Wording matters.
Mhm.
So I do want to turn over to Gerard and the legal facets of live event production. Gerard, you specialize in live event production law. So what are some of the primary legal risks associated with music festivals? And in your opinion, how can they be minimized?
Number one, I would always say around insurance. So different types of anytime you have a live event, you got different types of liability. So, one could be just, people getting hurt. Another one is event cancellation insurance, especially if you're talking about outdoors. So pretty much all the festivals that I've ever worked on have always been, outdoors. So you're subject to the elements. So, could be rain, could be a storm. So really just kind of preparing for those things on the front end. I would also say, how you manage the talent as well too. So making sure your process is streamlined in terms of, you know, when people are paid, when the deposits are, that financial stress can be pretty serious, especially for like smaller festivals, not the larger ones that, some of the biggest promoters that we're used to hearing, like Live Nation, AEG. So really just kind of like, honestly, it's really just planning and being organized, and giving yourself enough time you can address some of those things on the front end.
How about from the side of the artist? What advice would you give to any sort of emerging artists about negotiating their performance contracts to ensure that they are fairly compensated and with regards to their rights as well?
Right. I would say, so in terms of the festivals, it's a little bit more of knowing, I guess, knowing your worth and where you fit into where you are in terms of your career. Obviously, most festivals work off of billing. So you're going to have your headliner at the top, and then you're going to have more of your emerging acts near the bottom of and trust me, it's like full on battle in terms of the slotting between
Out of
like
the
the agents and the managers. So that's a whole nother ball of wax right there. But I would say the things to always be cognizant of is always going to be like how much you're getting paid, when are you getting paid, um, and then if there's any other, you really get what you negotiate. So it's going to be if there's any other like transportation, lodging. Um, a number of festivals also have what's called radius clauses as well too. So that might mean, if you're performing on this festival, I have the right to your exclusive performance within 50 miles of the venue, 30 days before the show and 30 days after the show. And that's a way for the promoter or the festival to be able to kind of like protect their investment into paying the artist so that, the artist is not playing another show where, a fan might have otherwise wanted to see and pay for him to go to the festival, but they went to see him at this, this third party show. But um, if you ask for it, because again, if you're up here and you're one of the headliners or you're direct support to the headliner, um, you may have less wiggle room with that radius clause because they're dependent on you to sell more tickets. But if you're more of an emerging band and you're only making $500 or $1,000 on the show, you might say like, hey, we're not in this part of the country that often. It's important for us to be able to earn money on some of these other shows. Is there a way that you guys could relax the radius clause for us? And I've seen that happen quite a few times. And sometimes, there may be some nuance with it. Maybe after the show is sold out, or maybe once you get closer to the show, or maybe after the show. But again, I think, again, trying to be able to protect how much money you make and then the other opportunities that you could have around the festival are good as well. But generally, I would say all the great festivals, they definitely want the artists to have a great experience, because if they have a great experience, they'll tell other artists about it. The other people in the industry will tell them about it, and vice versa if they don't have a great experience as well too, which is not what you want.
That's a good point. I think anytime you see exclusivity pop up, whether it's a radius clause or some sort of non-compete, if you're representing like a brand or anything else like that, know that you agreeing to that impacts how much money, like impacts how you earn a living. So it always should be directly correlating to what you're getting paid. That makes total sense. It's kind of funny where like in this instance, yeah, a smaller a smaller band might actually have more leverage to push back against
Yep.
that because they're not getting paid as much. Have you ever had experiences? I would love to hear what the contingency plans are when artists don't show up for their time slots.
When the artist doesn't show up well, the one contingency is you're not getting paid. That would be the first one. Typically most festivals there's going to be some type of deposit, and then you're going to have the balance paid either at the show, right after the show, or maybe a few days after or a few days after the festival is concluded. Um, Typically, for the instance that you're talking about, it's always probably better to do it maybe a couple of days after the show, just in case something, goes wrong. But again, this is a leverage thing. So your headliner might, typically, with Afropunk, you might have a headliner that might say like, "Hey, we want to get paid like the day of the show, or like literally like right after. Like someone needs to." Now, typically, a lot of these shows are on the weekend, so the bank's not open or nobody's walking up with a check. So, but they might want to say like, "Hey, we want to see the wire either like right before or right after somebody gets off. But typically there's going to be like a little window right after. So the money is kind of one aspect you can kind of do, you can use to control that. But typically what's going to happen, like, especially if it happens like last minute, then you just skip that person and go to whoever who's next. Um, whoever's next in the lineup. Hopefully, it's not someone that's too big. I did have a scenario where we had a headliner in 2023, and she had a death in the family. She was like literally going to be the headliner, and she had a death in the family. And I was already kind of anticipating, like, I'm like not sure she's going to do it. Obviously for good reason. And she dropped out, but I think probably within over the course of this was like 3 weeks before the show, over the course of maybe 2 to 3 days, and she was at William Morris. So those guys, they got a list of people like, okay, this person can't go. Who else you got? They love to be able to replace them with someone else. And so we were able to kind of get it figured out, pretty quick, and actually within the same money range as well too that the other person who dropped out had to do. So you just got to kind of be flexible. But I would say obviously the further you are from the festival, the more kind of wiggle room you have. But there are going to be where that changes is if someone's been paid. So if someone's been paid, then you have to see like, okay, are they canceling because of something that the promoter or the festival did, or are they canceling because the cancellation is on them? But I would say one good thing about live events, at least from what I've seen, is that it's kind of symbiotic relationship between the promoter and the artist. Is like most likely you're gonna have to see that person again, especially in terms of like promoters and management companies or agencies. So it's like, if someone is going to be like difficult to deal with, then it's like at some point you're probably going to be on the other end asking them for a favor. So it's like, everyone kind of needs to look out for each other. I think that was kind of one thing that definitely came up during COVID when everybody was scrambling. So it wasn't, we kind of got to a point where it wasn't where everyone that's like, okay, well, we got to cancel at the last minute. And either we work something out where you guys keep your deposit, and then when we come back, we'll have the same lineup instead of one side being just like, oh, hey, like, you got a once in a century, like, pandemic, like, you guys got to cancel, like, you guys owe me all this money. So it is more like where everyone kind of needs to look out for each other. Doesn't always happen like that, but I see that more in that area of the music industry than I do in others.
That
What
makes
are
sense. We certainly had when COVID hit in our industries that we were working in, but a bunch of people just go, sorry, it's not happening. We're gonna keep the money, walk away type thing. It was not good.
Right,
So it's glad to hear people are a little friendlier in the festival space.
right.
So what would you say are some common pitfalls when navigating licensing and permits for live events, and how can organizers effectively manage these?
That's a good question. Again, I think it kind of goes back to not planning properly and giving yourself enough time, especially for any type of live event. You honestly, you probably need a year to be safe. Maybe like to really kind of knock everything down. So you're gonna have local permits that you need to. So we're close to New York City, so I've dealt with that department before. So the Parks and Recreation Department, kind of being ahead of that. And then you kind of need to know, a lot of times festivals that have like a site map, so you know everything that's going on. Are you going to be serving out? Are you going to be serving beer and alcohol? Like that's another area where people, and that's a serious one, because if you don't follow any guidelines, they could just come and shut you down. Uh, we had a scenario one time where someone, um, he I think I told Adam about this one.
I
The
know this story.
guy, he didn't. He was going to be a vendor, but he never got the proper permits to be able to serve alcohol. And I don't know how it like slipped through the cracks where like he was literally like there day of, and when it was about to start setting up, and then when we found out like the guy didn't have the permit, it was like, oh no, man, like you can't serve. And the guy was like didn't understand like why I didn't need to have permits, which was just crazy to me if you're someone that's serving alcohol. But I had a colleague that actually used to work for whatever the alcohol or commission is for the state of New York. And she pretty much was like, if someone's serving and they don't have the proper permits, they could literally come and shut the entire festival down, like the whole thing. And it also creates liability for you from an insurance standpoint as well too, because that might be part of the coverage that you have deals with, serving alcohol. But obviously the insurance companies, I'm like, oh, well, like if you didn't make sure that someone had the proper permits, then it's like we could deny you coverage. So again, just kind of knowing all the things ahead of time that you're going to have on the site, like your caterers, and then obviously everyone needs to have a contract. So that's one thing, because again, like your insurance company may not cover some of these things if you haven't taken the proper steps to mitigate risk. One pretty cool thing, it only happened one time, but and I want to say maybe like 2017, we had an insurance broker come on the festival I was working on, and he pretty much walked me around the entire festival grounds and was just showing me like, hey, this is why we do this. This is why we do risks. Like, one example that I always think about now is um, when you have any type of street closure, they'll put these huge like dump trucks to like block the street, just because you never know, someone crazy person like drives a car through a crowd. But like that's one reason that, and you'll see that at a lot of other festivals. I know South by Southwest is one of them where I've seen the same thing, where it's like they won't just have barricades, like they'll have some huge like system to stop. Something just happened in New Orleans at the start of this year as well too, which kind of made me think about that as well too. So it's like you really got to be proactive in terms of the risk. When I was in law school, they used to always say contract for the best. I mean, hope for the best, but contract for the worst. So that's kind of always like my mindset. Is just kind of think like, okay, what potential issues could we have here, and also like you kind of got to know your crowd too, I would say. So like, I worked on Afro punk for a long time. That crowd is probably a little older. I would say maybe like mid 20s and up, mid 20s to like 50s, and people just want to listen to music and probably smoke some weed, like most of your kind of chill music festivals. But then one year I went to Governor's Ball, and it was just like my
Wow.
mind was like, this is like wow, like guys were like climbing the stanchions, and same thing with Rolling Loud. It's a much younger crowd, like 18 to mid 20s, a lot of drinking. So I think that's kind of part of it as well too, kind of knowing like knowing your personnel as well too. But really comes down to planning and knowing all the type of different functions you're going to have at your event.
So now I would like to talk a little bit about intellectual property rights in a festival setting. And, so live events feature a wide range of IP. How do you protect these rights in a festival setting? And what are some of the challenges for licensing music for such events?
Right. So one of the every live event, you're going to need to have a public performance license. Typically, you get that from ASCAP, so the big PROs, so ASCAP, BMI, and it's actually not a lot of money. I don't know if people realize that, but basically what they use is like a formula. So if your event is 15,000 people, maybe you made $1 million. I forget what the exact formula is, but basically it's like a formula, and then it's like basically like a very small fraction of that's paid to those PROs. So want to go to ASCAP, want to go to BMI, want to go to the other CSAC, want to go to the other PROs, but that covers all music that's played at the event. So that's kind of one thing that you definitely need to have, because if you don't have it, they could cause problems. They could cause problems for you later. The PRs can come after you. So that's kind of one thing. And then in terms of those agreements with the artists, which kind of goes back to what we were talking about before, it's like there's going to be other rights that are kind of implicated. So typically, what I would see is, someone performs live, but are you capturing that performance as well too? Are you filming it? Okay, then if you film that performance, how can you use that performance? A lot of times artists won't have a problem using it for promotional purposes, which means like, okay, we had, Gerard Festival in 2023, and I want to use Erykah Badu performing on my festival last year for Gerard Festival 2024. But I could only use it to say like, hey, here's just a little short clip of Erica performing, and I'm just using it to sell tickets. Now, if I was using it to where I took the whole performance and I just threw it up on YouTube to say like, hey, here's some performances from, like, now that's different because I could be monetizing the YouTube. I didn't get permission from her.
How would that differ from, let's say, doing a live stream simultaneously with the festival and charging users money to view the live stream?
So you absolutely have to get the permission for the live stream for the artist, and they are very, even during the, I guess, like peak COVID where there was a lot more of that happening. There's a lot of like there's a lot of pushback on the live stream, and you get a couple of artists where just like they also don't want people to see like the show that they're putting on as well too. I know we had an issue one time with like Kid Cudi. Like it was what I thought. Kid Cudi is probably rich, by the way, but I thought it was a lot of money. But Kid Cudi was like, "Oh no, like even at that amount, he's like, there's no way he's just not gonna agree to the live stream." So the right to be able to live stream someone's performance is going to be in the bundle of rights that'll be in that contract that you have with that performer, and then separately, uh, um, if you're on, depending on the platform, you may also have to whitelist some of the songs as well too. So that's going beforehand and saying to YouTube, like, or whoever it is, like, hey, these songs are going to be played. You might have an algorithm that might otherwise like take this song down. This came up a lot during COVID with DJs as well too, because they're like, oh, uh my stream keeps getting taken down because I'm playing music. But obviously, like if it's a DJ, like they're not going to own the music. So some of the platforms have to adjust that. But these are all kind of things that kind of go into the different kind of bundle of rights. Another one is merch as well too. So um, you if you're using someone else, sometimes you'll see festival merch, but they may have like I know one. Actually, I really enjoyed this, but on Afropunk, they would have merch where you'd have the lineup on the back of the shirt as well too. That was something else that you would need to get permission from, just for the name to appear in the lineup. I don't ever recall there being an issue with that, but again, you're using somebody else's name commercially, so you do have to kind of clear that. So those are all rights that can be implicated, but they should definitely be addressed in the agreement, because if you don't address them, like the presumption is going to be that that artist still owns that. They haven't given you that right.
Right. I've never even thought of that. That's so cool. I have so many festival t-shirts, and like now when I go how many contracts were involved just like it makes the t-shirt. So before we turn over to our Q&A, kind of just as a final topic, so revenue and business models. Could you share some insights on developing successful financial models for festivals and taking into account the various revenue streams and overall economic impact of these events?
Yeah, I think you have to. It's going to depend. It's going to depend on. It's definitely not a one size fits all, because it's going to depend on the market, like all the foundational pieces of the festival. So, where the location, the capacity. So how many festival goers, how many tickets are you looking to sell? Are you looking to lean a little bit heavier on the sponsorship, which is probably like the most popular model, where people are expecting to sell a certain amount of tickets, but typically the sponsorship is what's going to pay for a lot of the costs afterwards. But again, if you're doing that, you have to kind of start early so you're able to get those sponsors in as well. So it's going to be real kind of dependent on what type of show you have. I think what I've seen is kind of scaling up over time and starting with a smaller show, and then kind of going up from there is a great way to do it, as opposed to kind of just swinging for the fences immediately. That may not be the most sustainable. So I think kind of scaling up over time, where you kind of add these different features. How many acts are you going to have? Are you talking about 1 day or 2 days? How many stages? Because again, the more acts you have, the more stages you have, the more money that you're going to need to spend. So I think, and there's been a number of festivals over the years, whether it's international or domestic, that have come about. But I think really kind of taking their time and building it and not trying to do everything the first year, it's kind of been the most successful approach.
Hmm.
Before we turn to questions, and I will say the chat is open. If you have any questions about anything we discussed today or anything we didn't discuss, feel free to just chat it in. We'll read it out loud. I gotta ask Gerard, it's probably on a bunch of people's minds. I already see smirking. What are your thoughts on Firefest coming up?
I'm intrigued. I thought that the original idea was amazing. The original idea was amazing. It was like, okay, we're gonna have this ridiculous luxury festival. We're gonna have people perform. We're pretty much making a trip out of it. I even remember watching, which is funny, Adam, because I guess this is more your world. Like they had all the influencers that were in the first video promoting it, and I thought that was well done. Obviously, the execution was horrible.
I worked with a few of them that were promoting it, and the aftermath was awful for them. It was fascinating to
Yes,
see, but also terrible at the same time.
yeah, it was bad. It was very bad press. I actually saw a video recently of Ja Rule. I think he was promoting a liquor brand, and someone, I guess they just had to ask him like, "Hey, are you going to attend the Fire Festival 2, Fire 2 that's supposed to happen in May?" And his look was like he wants no parts to do with any of that anymore. But to your point, everything that we talked about are implicated. And even if someone went and watched, I think there's 2 documentaries on Fire Festival, one's on Hulu, I think the other one's on
They're
Netflix.
good.
They're fantastic. Everything that we just talked about is implicated in all those things. It's like the planning, the permits, how you handle the artists, the fact that when the artists weren't, it was clear they weren't getting paid, so then now like they're canceling. um what was the business model, like all those questions are, so actually like a great like test case for what not to do, but like all these issues that we're talking about. But I am curious to see if he's going to pull it off, because people are saying like he's steadfast that it's happening in May. I would be curious to know how many tickets he sold. He didn't say that in this Billy McFarland.
Are you going?
I'm not I'm not going. I'm not going.
All right. Well, with that, we've got about 10 minutes to go. If anyone has any questions, please enter them into the chat. This is always when the fun stuff pops up. So we are looking forward to that. Give everybody about 30 seconds if they have anything in mind. Lorraine, you want to maybe jump in with your own questions while we're waiting for people to chime in?
Of course, yes. Okay, so Gerard, so how about talking about some safety protocols and crowd control measures? So what are some of the legal considerations that are really important for implementing both those things?
You got to have proper one, security. Obviously, I don't think I even mentioned security, but definitely the proper security. And there's a lot that goes into that. So obviously you got safety, you got crowd control, you got ingress and egress. And really, I would say if you have a really good insurance broker, just like the guy I referenced, they'll know all those things. Like, this is how this is how this should be set up. This is a risk, this is not a risk. So you got to really kind of think through all those things on the front end. But I know one of the big ones I've seen is always like ingress and egress, because particularly with Afropunk, where it was in Fort Greene, like later in the day, there would definitely be like certain kind of like bottlenecks where you get like a lot of people in a very like packed in kind of place. And that would always kind of make me a little bit nervous. So that would definitely be, I think, kind of like just kind of thinking through the site map. It all goes back to the site map. So how people are going to be moving around and how many exits you have. But crowd control is definitely a big one for sure.
And Adam, so going back to you and just to intellectual property rights for, they're a cornerstone of branding and merchandising. How do you navigate merchandise agreements to avoid infringement and to protect your designs?
That's a good broad question, but well, first of all, it's usually when our clients are working to create merchandise, they're working with some sort of a manufacturer or vendor who's handling that. And You just really need to be careful when you're delineating between I'm the artist or I'm the brand with certain IP versus you're the manufacturer who's creating stuff for me, who's responsible for what. And this goes for t-shirts, this goes for hats, this goes for albums, any product that you're creating, this goes for comic books, like you name it. And setting that out clearly is really, really important. It's pretty common to receive like a vendor agreement or a brand agreement that puts all the responsibility on one side, but you realize when you're working with other parties to create something, both sides are contributing, and you need to make sure that both sides are actually clearing whatever their contributions are, whether that's a publisher, whether that's just a factory that's building stuff out for you, whether it's a designer you're hiring to take maybe your logo and turn it into something else. You need to make sure that you have that. And then the pieces too, never take for granted that the stuff you're giving over is actually owned or controlled by you. You know, if you took something off the internet and kind of just changed it slightly to make that your logo, that might not be completely owned by you. These are things you need to think about, especially as you're moving from being an artist and releasing what I would call, you know, artistic endeavors, whether that's a video online, a song, something like that, which there's maybe a little bit of flexibility on how you can use it. The second you move into the merchandise world, you know, we're going from capital A art into more commercial, then things get a little trickier, things get a little riskier, and the likelihood of getting caught for copyright infringement or trademark infringement just skyrockets. So the second you're making that jump into that world, or you say, I want to make merchandise for my audience, or I want to make merchandise for my fans, you have to be a lot more deliberate with how you're doing things.
Have we gotten any questions from the chats?
No questions from the chats. I think we'll leave it at that then. I guess we've been so comprehensive that everybody is just finished
They
for
feel
the day.
prepared.
Yeah, but I'll leave us with this. Gerard, thank you so much for joining
Thank
us. If you missed part of the Zoom, we're going to be sending out the full recording later this month with more information. Gerard's information will be in that email too. So if you want to reach out to him, by all means, please do. Really appreciate joining in. This is going to be just one in a series of continuing webinars. We will be doing another one next month. So please follow us on LinkedIn or on Instagram if you don't already. And if you have any questions, by all means, please feel free to reach out to any of the three of us. Thank you so much for joining. Gerard, any last words?
Thank you guys. Thank you for having me.
All right. Well, take care, everyone, and we'll see you all next
All right.
one.
Bye.
Take care, guys.